Alright, let me move on. I want to clarify the record in case it wasn't clear. During the bench conference, there was an objection raised. Ms. Young wanted to pursue a line of questioning related to previous experiences she claimed, specifically mentioning a form of assault and references to a lack of therapy. My ruling was that I had not seen any relevance to those points. Those seem like arguments for mitigation. Why perhaps she should receive a lesser sentence if found guilty. But the jury's role is to determine the facts of whether these offenses occurred, and I haven't seen how a previous sexual assault or a lack of therapy bears on that determination. However, if you'd like to further argue the point, now is the time. When I first hired Lee Howard as my lawyer, he was told about the incident multiple times. I'm not sure why that information wasn't shared with the court. At the time, I wasn't familiar with the legal process or who to contact. I trusted him to do his job. To my recollection, it wasn't unknown what happened to me. There was a night when someone came after me. I don't know who they were, but they had a Polaroid picture of me carrying my son to my friend's house. I remember it vividly. I had a blue blanket, wore a black outfit, and my usual headscarf I wear outside. When I saw that photo, in the midst of everything happening, it was horrifying. On the day Captain Winfrey, I'm not sure if she's still a captain, threw me a baby shower at the jail, I was already uneasy. Even when I first began working there, I was called out for how I walked, as if I walked like a model or was twitching my hips, and that put me on the spot in front of everyone in 6 North. There's no way for me to know if this attention stemmed from the baby shower, especially since she invited my parents without my knowledge. Had I known she would do that, I would not have invited my parents, as I always kept my work and family separate for this exact reason. My son was in danger. I was in danger. There was even an incident that happened in the car. Clip 2.
And let me move on now. I want to perfect the record just in case it wasn't clear during the bench conference. There was an objection made. Ms. Young wanted to go down a line of questioning related to some previous experiences that she has claimed, specifically, I think, a form of assault, maybe references to a lack of therapy. And my ruling was that I had not seen any reason or relevance of that. Those sound like arguments of mitigation of why perhaps you're not as culpable as as the state might allege, that you should receive a lesser sentence if you're guilty of these offenses. But the issues here for the jury to determine are the issues of fact, of whether you did in fact commit any of these offenses. And I haven't seen how a previous sexual assault or a lack of therapy essentially bears on the determinations of this at all. But if you want to further argue that or be heard on it, now's an opportunity for you.
When I first hired Lee Howard as my lawyer, he was told of the instance multiple times. I'm not sure as to why you all didn't get it. I was not familiar at the time of the court's process and who I needed to reach out to. I let him do his job. But it was not to my recollection that they did not know of what happened to me. But yes, there was a night that I went door. Are you asking me to?
No, I don't really. I'm trying to stay big picture, which is what is the reason why the jury needs to hear about this?
Well, I don't know who the person was that came after me. Not only did they come after me, but they had a Polaroid picture of me carrying my son to my friend's house. It had a blue blanket, had me with my black outfit on, and I had on a headscarf that I always wear outside. When I saw that picture in the midst of what was happening to me, not only on the day that Captain Winfrey, I don't know if she's still captain, but at the time, she threw me a baby shower. Even when I first started working there, I was called out by, I believe, Captain Winfrey. Captain Winfrey?
Captain Winfrey is who we just heard from.
No, that was Grady.
Oh, I'm sorry. Excuse me. That was
okay, so yes,
Lieutenant Grady.
It's been a minute. I'm trying to remember names, but she threw me a baby shower at the jail. And when I first started walking there, I was called out for the way that I walked. I walked like I'm a model or twitching my butt or something. And that put me on the spot for everybody in 6 North. So there is no way for me to know if it was because of the baby shower, because she invited my mother and father without my knowledge too. And if I had any If I hadn't acknowledged that she would do that, I would not have invited my parents there, because I keep my work separate from my family for this reason. My son was in danger, I was in danger, and there was a instance that happened in the car. But I got
I'll be honest with you.
from that.
I'm still not sure what she's talking about, because she consistently starts to.
Okay, let me try to break this down. Are you claiming that someone, either an inmate at the jail or an employee, may have been responsible for the sexual assault? I don't know who the person was. The incident occurred outside the jail, but I was working with Fulton County at the time. I had parked my car, but didn't lock the doors. I was having internet issues and even tried calling DoorDash customer service afterward to figure things out. To clarify, the incident didn't happen inside the jail, it happened outside, but it was during the time I was employed there. The objection was raised when I asked Lieutenant Grady whether he had any awareness of the baby shower. The reason I believe he might have known is because everyone at the jail is connected, they're constantly meeting and talking. The baby shower was a surprise, and someone had to access my personal information to organize it. Maybe it came from my supervisor, maybe from Captain Winfrey, maybe even from Lieutenant Grady. It could have come from an inmate. I don't know, but whoever it was had access to private details, including my family. That's what concerns me. If my family was invited to the jail without my knowledge, someone could have followed them or obtained information about me through that connection. I was later assaulted, and the person had a Polaroid picture of me carrying my son, wrapped in a blue blanket. I was wearing my usual black outfit and headscarf. They had that photo, and it terrified me. It made me feel coerced, like I had to comply with their demands, possibly even smuggling things into the jail, because I feared what they might do. They had a picture of my son. What if the next photo is of him at daycare? Or of me coming into my home? Or even of my father? The state's position is primarily about focusing on process and procedure. The court acknowledged that if I choose to testify, I can go into more detail about these experiences. However, at this point, they don't believe there's enough evidence to justify questioning other witnesses, like Lieutenant Grady, about the baby shower or the assault. The judge agreed and noted that the relevance of the baby shower is unclear right now, but acknowledged that the next witness, who is believed to be the one who threw the baby shower, may provide more insight. I was advised to be careful with my phrasing when questioning that person, as objections regarding facts not in evidence could arise again. We'll have to see where that takes us. Clip 3.
Okay, I'm just trying to break this down. Is it your claim that someone from an inmate in the jail or another employee there
that may have
did this sexual assault?
That may have been the one to do. I don't know who the person was.
Where did it occur?
I tried calling DoorDash to get in contact to see if I can get it, because I called customer service. I parked my car, but I didn't lock my doors. I was having issues with the internet.
Let me rephrase. Did this incident happen inside the jail or outside of the jail?
Outside the jail, but I was working with Fulton County at the time.
All right, so the objection came, you were asking Lieutenant Grady whether he had some awareness of a baby shower and that sort of thing.
Mm-hmm.
Do you have any reason to believe that he did?
Because if he's aware of the baby shower...
Oh, no, that's not my question, not if he is. Do you have any reason to believe that he was aware of the baby shower or your sexual assault? I
would think he does know about the baby shower, because they're all connected. They're always talking, having meetings and whatnot. And it was a surprise to me. So it's like, how else would you get my personal information if you maybe talk to my supervisor, maybe talk to my captain? We've had issues in the past as well, nothing detrimental, but I still need to know where it could have came from. Anybody. It could have came from Captain Winfrey. It could have came from Lieutenant Grady. It could have came from the inmate.
What could have come from them?
If my family was invited to the jailhouse, they could have been followed back. Someone could have been like, here's her information. Because with that situation, me being touched, I was forced to bring whatever they wanted into the jail, because they have a picture of my son. Who knows if the next picture might be him at his daycare or me coming into my house. My father.
Okay, I understand. So any position of the state, I mean, I'm just trying to focus on process procedure here.
Right.
The things that Ms. Young is saying, I think that if she chooses to testify, she can go into them.
I agree, Your Honor, but I think at this point, I don't think there's sufficient basis for her to ask witnesses regarding some type of baby shower. I'm just not clear as to the nexus or the sequence of the events that would make it relevant at this particular point in the trial.
Okay. I agree with you there. What we're focused on is, I mean, at this point, I don't think it would be, maybe this additional, I think you said lieutenant that's coming may have knowledge of this potentially that she could ask about.
That is the person who threw the baby shower initially.
The person who's coming next?
Yes.
Okay, well, glad we're talking about it now then. All right, well, I think then you can ask this next witness some of these issues. You're going to have to be careful with your phrasing. I think the state's objection to facts, not in evidence, is one that could very well come again.
Okay.
And we'll see where that takes us.
Hey, how you doing? I just want to state for the record that I have identified the wrong person. This is not the correct individual. Wrong name. All right. Just for the record, Mr. Miller, could you summarize what exhibits are in the stack that's going back to the jury? Mr. Miller responded that the following will be going back. States Exhibit 1, which is the Hope document. States Exhibits 3 through 9, which are photographs taken outside of the jail, along with the social media posting. States Exhibit 12, which is the evidence log. States Exhibit 22, the Caduceus report, and States Exhibits 23, 24, and 25, which are the GBI lab test results. Everything else will be held back. The court then stated that the redacted indictment, Courts Exhibit 1, and the verdict form, Courts Exhibit 3, will also be placed on top of that stack, and once the consolidated charge is prepared, it will be added as Courts Exhibit 4, making the stack complete and ready to go back to the jury at the end of the charge. A copy of the oath may also be added, provided it's shown to Ms. Young first, even though it's already part of States Exhibit 1, which could be seen as redundant. In response, the defense objected to including the oath of office. Ms. Young stated that she needed to review her own documentation because she believes the typed signature may not match what she actually signed when she began working with Fulton County. She expressed uncertainty and said she would need to check her docket to verify whether the signature is accurate. That was her only objection.
Hey, how you doing? Just stating on the record, I do have the wrong person. This is not the person that was, wrong name.
All right, just for the record, Mr. Miller, can you summarize what exhibits are on the stack that are going to the jury?
What will be going back to the jury will be States Exhibit 1, which is the oath. States Exhibits 3 through 9, which are photographs outside of the jail, as well as the posting. States Exhibit 12, which is the evidence log. States Exhibits 22, which is the Caduceus report, and States Exhibits 23, 24, and 25, which are the GBI lab test results.
Everything else is going to be held back?
Yes, sir.
All right. I'm going to place the redacted indictment, Courts Exhibit 1, and the verdict form, Courts Exhibit 3 on top of that. And then when we have the consolidated charge as Courts Exhibit 4, we'll include that in the stack. And that will be ready to go back to them when we complete the charge.
And Your Honor, may I place a copy of the oath?
If you've already got it, just make sure you show Ms. Young that before you do so. I mean, it's a bit redundant since it's also Exhibit 1, but all right. So based on what was just said on the record, is there any objection on behalf of the defense as to what would be going back in the jury room during deliberations?
I would say the oath of office. I object to it because that signature, I have to look over my own document again. My signature, if I'm not mistaken, I signed something else. I'm sorry, let me rephrase that. That typed signature, I'm going to have to look at my document and make sure it matches because I'm not sure, I'm not too quite sure if that matches what I actually signed when I started working with Fulton County. And that's all.
All right. Well, if the only objection I'm hearing is regarding the authenticity of this document and whether it should be considered by the jury, that ship has sailed. The document was already admitted without objection. Therefore, since no valid grounds remain, your objection is overruled, and Exhibit 1 will be sent back to the jury. Are there any other objections? No objections. All right. We'll hold for now until we have the consolidated version of the charge, which should take a few more minutes. Are the parties requesting any additional time to prepare for closing arguments? The state replied they are ready, though one person requested a brief bathroom break. The judge asked if they would need a PowerPoint or any other equipment. The response was yes, and the attorney said they would simply take their laptop to the podium and conduct the closing from there. The judge confirmed that this person would be delivering the closing, to which they affirmed. It was also clarified that the defense will go first and deliver both the opening and closing portions of their argument in one go. The state will reserve their first closing, meaning Ms. Young will begin first once closing arguments commence. The judge concluded by saying they'll take a 15-minute recess to allow everyone to prepare and practice their PowerPoint, and the jury was informed to be ready in about 15 minutes. The court then recessed at 1:50. Clip 5.
All right. Well, if that's all, the objection I'm hearing is to the authenticity of this document and whether it should be considered by the jury. That ship sailed when it was admitted, and there was no objection. So those being the only grounds, then your objection is overruled, and Exhibit 1 would be going back. Any other objections?
No objections.
All right. So we're holding in place until we have the consolidated version. That's going to take maybe a few more minutes. Are the parties requesting some additional time to prepare for closings?
Your Honor, state's ready.
I just need a brief bathroom break.
Of course. Do you need a PowerPoint or anything else like that?
I do, Your Honor. So what I would do is I would just take my laptop, if I can, with me to the podium, and I'll just conduct it that way.
You're doing the closing?
Yes, Your Honor.
Okay. And you're opening and closing?
Yes, I'm going to do the close. So defense can go first, and I'll do everything at one time.
All right. So the state's planning to reserve their first closing. And so what that means, Ms. Young, is you'd be up first when we come in and begin closing arguments.
Okay.
And so we'll just take 15, prepare what you need to, practice your PowerPoint, and just let the jury know about 15 minutes we'll be ready to go. We'll be in recess.
Thank you, Your Honor.
5. All right. We are now back on the record. The time is just before 2:05 p.m., which is approximately 15 minutes past the 1:50 p.m. time I instructed the parties to return, so we could begin closing arguments. The state is present. However, the defendant is not. I have asked our deputies to search the floor. She has not been found. They also checked the restrooms, and she is not there either. We are now attempting to reach her via phone. The only contact number we have is for her mother, who previously conveyed a message to ensure her appearance on Monday morning when the trial began. At this point, we are also reviewing security footage to determine whether the defendant exited through the courthouse's front door. Observing the defense table, it appears that all of the documents and materials the defendant brought are no longer there. She has left a jacket behind, but otherwise, her belongings appear to be gone. Given that we are well past the return time and she is still missing, I believe the defendant has waived her appearance. Under applicable case law, the trial can proceed in her absence. I am instructing the deputies that if she returns at any point, she should be allowed back into the courtroom and can resume her participation. In the meantime, we will proceed. Mr. Miller, are you still ready to begin closing arguments? If so, let's bring back the jury. Clip 6.
We are now back on the record. The time is just before 2:05. It's about 15 minutes past when I instructed the parties to be back at 1:50 to begin closing arguments. The state is present. The defendant is not. I've asked our deputies to search the floor. They have not found the defendant. They've also sent someone into the bathrooms. She is not in any of those. And we are also now trying to make a phone call. The only phone number we have is to her mother, who had previously conveyed a message for us Monday morning to have her here to start trial. And at this point, we're also going to review security footage to see if she walked out of the front door of the courthouse. But looking at her table, it looks like all of the papers and things that she came with are not here anymore. She left a jacket behind. But otherwise, all of her belongings are no longer here, from what I can tell. and we're now well after the time I told her to come back. She has not been spotted anywhere on this floor, and so I believe that she has now waived her appearance going forward through this trial, and we can proceed even in her absence under our case law. I would instruct the deputies at any point, if she shows up, she should be let in, and she can resume being here. But until she does reappear, we're just going to proceed. So, Mr. Miller, are you still ready for closing arguments? Then let's bring back the jury.
Is this for me? Judge, is this hers? I don't know what that is. They're jury charges. Yeah, that's hers. Miss Boren just went to the office, but she's on her way back now. Okay. Well, I think we can go ahead and put some things on the record that we need. I need paperwork out of my bag, if that's possible. Okay, one SEC 1 second. All right, let's go back on the record. First, I would like to perfect some information we received during the break while the jury was deliberating. I had requested, thank you, Lieutenant Lattimore, to review the surveillance footage in an effort to locate Miss Young. He was able to observe footage, so I'd like Lieutenant Lattimore to describe for the record what he saw. You may proceed, Lieutenant. Yes, Your Honor. I reviewed surveillance footage and observed Miss Young exiting the 136 checkpoint at approximately 1:51 p.m. From there, she proceeded down Pryor Street, heading south. She then made a left onto Mitchell Street and continued east until she reached Washington Street, where she made a right turn. At that point, we lost visual contact with her. All of this was visible through the building's external surveillance footage. And this area is several blocks away from the courthouse, correct?
Yes.
All right. Miss Young, where were you going? Before I answer that, I had previously stated that I believe this court was in contempt of justice due to failure or refusal to proceed in equity under exclusive jurisdiction. Did you not acknowledge that we were in equity jurisdiction? If there's anything else you'd like to say, Miss Young, this is your opportunity to have it on the record. I'm not going to get into a back and forth with you. I simply want to know if there was some kind of emergency or personal issue that caused your absence. Otherwise, we will proceed. I did need something to eat. I haven't really eaten since last night, and I'm pregnant. I felt like I was about to pass out. I also forgot the time we were supposed to come back. I got a call from my mother saying I had an hour, so I assumed I had more time. I apologize for that, Your Honor. All right, let's break this down. It's now approximately 4:30 p.m., and I believe security found you trying to re-enter the courthouse around 4 p.m. You're saying you got a call from your mother indicating you didn't need to be back for an hour, but we had actually called around 2 p.m. to begin closing arguments as scheduled. If I can look at my phone records, I can confirm that my mother told me I didn't need to be back for an hour because someone from the court had called her. I also updated my contact information, including phone number and email address, in the Odyssey system. I don't understand why the court continued contacting my parents instead of the updated number I provided.
Me. Judge, is this hers?
I don't know what that is.
This is jury charges.
Yeah, that's hers.
Yeah.
Your Honor, Ms. Boykin just went to the office, but she's on her way back now.
Okay. Well, I think we can go ahead and just put some things on the record that we need.
I need paperwork out my bag, if that's possible.
Okay, one second. Okay.
All right, let's go back on the record. And first, I would like to perfect some information we received while we've been here on break during deliberations, which is that I requested
Thank you.
Lieutenant Lattimore to review surveillance footage to try and help us locate Miss Young, and he was able to see some footage. And so I'd like Lieutenant Lattimore to share with us for the record what he was able to view and what he observed, and then we'll go from there. So you could just describe that for me, Lieutenant Lattimore?
Yes, Your Honor. I was able to review footage of Ms. Young exiting the 136 checkpoint at approximately 1:51. And from the checkpoint, she proceeded down Pryor Street, which is south of us, and made a left at Mitchell and Pryor, and proceeded east on Mitchell up to Washington Street, where we observed her make a right turn. And at that point is when we lost sight of her movement.
And this is all through surveillance footage you're reviewing after the fact?
Yes. Yeah.
And that's several blocks away from the courthouse. All right. Ms. Young, where were you going?
Before I answer that, I previously stated that you were in contempt of justice, because of failure or refusal to proceed in equity under exclusive jurisdiction. Did you or did you not acknowledge that we were in equity jurisdiction?
If there's anything else you want to say, Ms. Young, this is your opportunity to have it on the record. But I'm really not interested in getting into a back and forth. So if you had some kind of emergency come up or something else you needed to address, that's what I was kind of curious about. But otherwise, we're going to move on.
I did. I needed something to eat. I haven't really eaten since last night. I'm pregnant and I felt like I was about to pass out a little bit. I did kind of forget what time we had to come back. But I got a call from my mother stating that I was supposed to be back in an hour. So that was what took me so long, because I went to grab something to eat and I was going to come back. But after I got that call, I was like, okay, well, he did extend the time. But there was miscommunication there. So I apologize for that, Your Honor.
All right. So I just want to break that down, which is it's now about 4:30, and I think they found you trying to re-enter the courthouse about 20 minutes ago or so closer to 4 o'clock. And so you believe that you got a call from your mother saying you didn't have to be back for an hour. And I think we called around 2 o'clock because we were trying to start closing arguments, as I'd indicated. If
I can look at my phone records, she called me and told me that I didn't have to be back until an hour because the court, whoever called her. And I've updated my phone number, email address in the Odyssey system. So I'm not seeing why I'm getting reports that you all are calling my mother and my father instead of the phone number I gave.
Without absconding, a bench warrant was issued and the defendant, Miss Young, was remanded into custody for the remainder of the trial. The court noted her explanation was on the record but stated that due to a loss of confidence in her ability to appear on time for further proceedings, her bond was revoked and she would remain in custody pending the trial's outcome. Turning to the matter at hand, the judge presented Court's Exhibit 5, a written question from the jury, which was read into the record. The question asked, is there any statutory minimum for possession of a Schedule 1, 2, or 4 substance, respectively, where intent to distribute is presumed if you are in possession in excess of such amount? The judge stated the note would be made available for inspection by both the state and Miss Young, with deputies bringing it to her. Miss Young then attempted to interject but was instructed that it was not her turn to speak. The court continued, noting that while the law does allow for a presumption in trafficking cases, such charges were not included in this indictment. Therefore, the judge proposed responding with no, along with a rereading of the jury instruction regarding intent. Intent to distribute, as explained, must be inferred from proven facts or circumstances and cannot be presumed solely based on quantity. The judge emphasized that the jury should not place undue weight on that specific charge, but consider it within the context of the entire case. When asked for input, the state initially sought clarification, questioning whether the jury was referring to a minimum sentence. However, upon review, both the judge and state agreed the question appeared focused on whether possession of a certain amount alone could legally establish intent to distribute. Finally, Miss Young insisted on placing on the record her claim that the court was in contempt of justice by refusing to proceed under what she described as equity jurisdiction, though the court did not engage further on that point. Clip 8.
Well, I think we've put your explanation on the record. You can, and so that's all well and good. However, I've lost confidence that we can expect you to appear on time for court proceedings, so I've revoked your bond, I've issued a bench warrant, and so you will be in custody pending the outcome of this trial. More to the present business at hand. No, it's not your turn, Ms. Young.
Oh, okay.
I do have Court's Exhibit 5, which I've marked and will tender for the record, which is a question from the jury. It states, and is available for inspection for the parties once I'm done reading it into the record, is there any statutory minimum for possession of a Schedule 1, Schedule 2, or Schedule 4, respectively, where intent to distribute is presumed if you are in possession in excess of such amount? And it's signed by the foreperson. And so if either party would like to, if the state would like to see it, you can come up and grab it. And if Ms. Young would like to see it, deputies can take it to her.
This is a question from all jurors or specifically?
It's from the jury.
Okay. And though you're failing or refusing to proceed in equity under exclusive jurisdiction, you acknowledge that on the record as well?
All right. My proposed response to this would be
you can't
no.
deny that injustice.
And that I would just write on the note, no, and that we would refer them to their previous instructions. Technically, there is a presumed amount, but that's for trafficking, and that's not been charged in this indictment. They asked specifically about the intent to distribute, whether that's ever presumed based on the amount. As I understand it, it is not. So I think it would be an accurate statement of law to say no, and then just refer them to their previous charges. Any input? First from the state.
So they say a minimum. Are they referencing a minimum sentence? An amount?
I take the question as a whole. It's a statutory minimum where intent to distribute is presumed. So I know we use minimum in reference to sentences, and that was my first impression as well. But reading it as a whole, it seems to be focused on the evidence of distribution and whether that intent can be presumed based on a minimum amount of drugs. And again, that's where I say the answer to that legally is no. Or actually, I mean, it really just says intent to distribute means intent to unlawfully deliver or sell. So maybe the actual relevant charge would be intent generally, which can be shown in many ways, whether it existed from the proven facts before you. It may be inferred by the proven circumstances or by acts and conduct. So actually, maybe what I would do is say no, and then just reread the intent charge, and then say that they should place no undue emphasis on this charge and only consider it in the context of the charge as a whole.
State agrees, Young.
All right. Any input from Ms. Young?
Yes. So you are not acknowledging the fact that you're in contempt of justice on the record, being that this is equity jurisdiction?
Ms. Young continued speaking, insisting on a response from the court regarding her claims about equity jurisdiction. She stated, "I need an answer because your failure or refusal to proceed in equity, being that you acknowledge the exclusive equity jurisdiction, will constitute contempt of justice." She asserted she had attempted to act as a respondent to all complaints and questions due to what she described as a legal and special relationship tied to a paid account, and that she was preparing to file relevant documents into the court system. She then asked the court, "Are you in contempt of justice? Are you recontracting the trust?" At this point, the judge reminded Ms. Young of previous warnings given at the outset of the trial about interruptions. As she continued to speak over the court, the judge declared her in contempt of court and imposed an immediate 20-day sentence, regardless of the trial's outcome. When she continued interrupting, the judge issued a second contempt finding and an additional 20-day sentence. Ms. Young responded, "You can do as you please because, at the end of the day, you have no jurisdiction. You are in contempt of justice, and you cannot refuse from the courtroom." As she was removed, she added, "You'll be hearing from my fee schedule, implying future legal or financial claims against the court." Clip 9.
Anything else?
No, I need an answer because being that I told you that your failure or refusal to proceed in equity, being that you acknowledge the equity jurisdiction, exclusive jurisdiction will constitute contempt of justice, I've tried to show you as respondent to all complaints and questions because of the legal special relationship that I have paid on this account. I was about to go and e-file it into the system. Are you in contempt of justice? Are you recontracting?
Are you done?
No, I'm not. Are you recontracting the trust?
You remember what I told you at the outset of this trial, which is that if we started getting into
You
it, you
haven't
started
answered the
interrupting
question.
me. All right, Ms. Young, I'm going to find you in contempt of court.
Are you
and
in
I'm
contempt
immediately
of
imposing a
justice,
20-day
though?
sentence, no matter what happens as a result of this trial. And I'm directing you not to interrupt me any further, all right?
You asked me a question, but you didn't answer it.
I'm
So
finding you
trying
in
to see how,
contempt a
as a
second
judge,
time, Miss Young. That is an additional 20-day sentence I'm imposing.
you can do as you please, because at the end of the day, you have no jurisdiction. You are in contempt of justice,
Please, if you could
and you
please
cannot
escort Miss Young
refuse.
from the courtroom.
Come
I
on,
find her
yeah.
as
You'll be here in my
disrupting our
fee schedule. Let me
proceedings.
put this up.
I got that. I'll bring
And
that
you know
back.
you're in contempt of justice. It's okay. You'll be here in my fee.
The court reconvened and Lieutenant Lattimore informed the judge that the jury had reached a verdict. Miss Young was present in the courtroom. The judge reminded her not to interrupt the proceedings and stated she would have an opportunity to speak when called upon. The jury was brought back in. Juror number 8 was identified as the foreperson. The verdict form was reviewed by the court to ensure it was properly completed and then returned to the foreperson to be read aloud in open court. The foreperson announced the jury's verdict. On all 10 counts, including possession of controlled substances, intent to distribute, crossing guard lines, and violation of oath by a public officer, the jury found the defendant, Miss Young, guilty. The verdict form had been signed, completed, and dated correctly. The court then allowed the state to review the form. The prosecution had no objections and saw no reason why the jury could not be excused. The court turned to Miss Young and asked the same. She responded by stating there was an object, followed by the remark, "You're still in contempt of justice, but that's it." Clip 10.
All right. We're back on the record. I've been informed by Lieutenant Lattimore that the jury has reached a verdict, and Miss Young is now present back in court.
The court reconvened for sentencing, and the prosecution began by stating that although the defendant does not have a prior criminal record, the recommendation is based on both the facts of the case and the defendant's behavior throughout the proceedings. The state emphasized that the defendant had not accepted responsibility for her actions, which included bringing contraband into the jail and placing others at risk, including inmates and staff. This lack of accountability, combined with the serious nature of the offenses, formed the basis for the state's sentencing recommendations. For the charges involving possession of Schedule I controlled substances, the state recommended that the lesser count merge into the more serious count, with a sentence of 15 years to serve 10. For the related guard line violation, the state asked for 5 years to serve concurrently. Regarding the Schedule II charges, the simple possession count would also merge, and the state again recommended 15 years to serve 10, with the related guard line offense drawing 5 years to serve concurrently. For the Schedule IV charges, the same structure applied, 15 years to serve 10 for the intent charge, with the simple possession merging, and another 5 years concurrent for the guard line violation. Finally, for the violation of oath by a public officer, the state recommended 5 years to serve concurrently. The overall recommendation reflects the seriousness of the offenses and the risks created by the defendant's conduct.